We're just going to get started. Hello, everybody. Welcome. My name is Elise Gresh. I'm the AAJLJ Executive Director. So as many of you may know, in an effort to better understand the Israeli perspective on various legal and political issues, and understanding that the AAJLJ believes is imperative for us to be able to address these same issues here in the US, several board members and myself went last year, when we could travel places, to Israel for meetings with government representatives, lawyers in the public and private sector, judges, media figures, academic experts. So the issues that we discussed include nation state law, challenges to the authority and power of the Israeli Supreme Court, Israel's presence in the West Bank and actions at the Gaza border, and conflicts between civil law and religious law. So after that, after our trip, we all had such a wonderful time and learned so much. So we have had 3 of our board members. Sorry, if everybody could please mute themselves when they join, that would be great. So we had Harold Halpern, Stan, and please hold on one second.
Okay.
So we had Harold Halpern.
Okay, let me just see your phone.
Because
I know this.
There we go. Okay, sorry about that. And they put on a number of presentations so far. So Harold has also been writing for the Sarasota Herald Tribune, and we've been following up on all these issues. So we are yeah, please. So Steve Greenwald, one of our presenters, our president as well, is going to say a few words, and then we also have a special guest here today, who I'll introduce after Steve speaks.
Hi.
Hey,
am I on? Yeah. Okay.
You're on.
Okay. Well, I just want to echo Alyssa's thank you to everyone for joining us today. And many of you have joined us in many of the other webinars that we have run this year. Like many organizations around the country, most organizations, I think, we had to, of course, utilize the technology of Zoom to have meetings. And what we found was that it was really beneficial to us in many ways in terms of the number of people we could reach, as opposed to sort of live meetings. The geographical reach was expanded considerably. And we've done, quite a number of webinars encompassing all different topics related to Israel, Jewish law, civil law, and so forth. And if you access our site, I think I'm right on this, Alyssa, you can find a list of all the webinars we've done, and also we record all of the webinars, so you can go back and listen to or watch some of the earlier webinars we've done. So again, I just want to thank everybody for participating. I hope you will think about, if you're not already a member of the AAJLJ, please go to our website and see what we do and what we're doing. As many of you know, we recently filed amicus briefs in the 2 cases in the US Supreme Court involving restitution for expropriations during the Nazi era in Germany and Hungary. We have a lot of things going on. We run a lot of programs. Once Israel is open again, we will do things in Israel. So please look at our website, join us if you're not already a member. If you're already a member, please continue to support us, and thanks for your presence today. Alyssa?
Thank you, Steve. So before I introduce our speakers, I would also like to introduce Brian Lipton. Brian is the AGC Regional Director of West Coast, Florida. And Brian I want to introduce him, and he has something very important, a very important report that he will share with us, and also I'll make sure that I circulate it to everybody after the program. So thank you, Brian.
Thanks, Alyssa. So first of all, I want to say I know why Harold Halpern loves this group. I love the kibitzing beforehand, and it sounds so AJC. And before I start, I also wanted to thank you for making my dad's day. My dad is online in the meeting because of all the money he spent sending me to law school, having me graduate law school, then tell him I didn't want to practice law. I really think it's his Hanukkah miracle for me to address a group of attorneys. So hello. I'm Brian Lipton, and I'm AJC's Regional Director for the West Coast of Florida here in Sarasota. I appreciate the opportunity. I'll be brief. I'm going to spend about 2 minutes talking about AJC, and then about 3 minutes sharing about a groundbreaking study we've just released. AJC, American Jewish Committee, is the leader of global Jewish advocacy. AJC is building a safer, more secure future for the Jewish people, Israel, and for all humanity. Founded in 1906, we're one of the earliest human rights organizations in the United States, and we believe that the best way to fight anti-Semitism is to fight for the basic human rights of all people. Our top 3 priorities are: number 1, combating anti-Semitism; number 2, to help ensure Israel's security and prosperity and cultivate new allies; and number 3, to promote pluralism and to protect democratic values. We have 24 offices in the United States, overseas offices in Berlin, Paris, Brussels, Warsaw, Tokyo, New Delhi, and of course, Jerusalem. And AJC has 2.5 million followers on social media. We're a global agency for a global era. Our report. So in October, AJC released the State of Anti-Semitism in America Report 2020. The report includes 2 surveys, a survey of American Jews and a parallel survey of the US general population. We need to not just know where Jews stand on anti-Semitism, but where the general population stands on it. The report is the largest Jewish organizational polling of Jewish Americans ever. Usually a survey with 200 to 500 respondents will be considered scientifically acceptable, but AJC wanted to go much further. So we surveyed 1,000 American non-Jews and over 1,300 Jewish Americans. They were interviewed in September with a 3.7% margin of error. We did this because of the importance of data-driven advocacy. So we now have the numbers to back up what we're saying about anti-Semitism. The report overall shows what you'd expect. There's deep anxiety among American Jews who are concerned about anti-Semitism, and a disturbingly lack of awareness among the general population about anti-Semitism in the United States. I'm not going to throw a lot of statistics at you. As Alyssa said, the report is free to the public. It's on our website, ajc.org. I believe Alyssa is also going to distribute it, but I just want to touch on a few main points. I think the 3 top takeaways are: number 1, Jews and non-Jews disagree about whether anti-Semitism is increasing. Although 80% of American Jews see anti-Semitism as increasing over the last 5 years, and I'm going to round off numbers because I'm going to be very brief, it was 82%. But if 80% of American Jews see it increasing, half, 40% of the general public believe it's increasing. Lack of knowledge of anti-Semitism, I want you to hear this because I found it incredible. Nearly half of the US adults had either not heard of the word anti-Semitism or did not know its meaning. That's tremendous. And I'm talking about US adults, not children. And then number 3 is non-Jews don't believe our views need to be taken into account while considering whether or not something's anti-Semitic. 70% of Americans said if a Jewish person or a Jewish organization said a statement is anti-Semitic, it would either not make a difference or actually make them less likely to consider it anti-Semitic. Just a few more points. 40% of American Jews feel less secure than a year ago. And a year ago, 2019 was horrible. American Jews continue to hide their Jewishness. Almost a third of Jews in America will either avoid certain places out of fear for their safety or comfort, or hide their Jewishness. You know what I mean? You know, taking the Star of David, putting it in your t-shirt before going into the gas station, or throwing a baseball cap on to cover your yarmulke. 1 in 4, 25% of US adults reported not knowing much or anything about the Holocaust. And then finally, nearly half of anti-Semitic content reported to social media platforms went unaddressed. That means 50% of American Jews who said they reported online anti-Semitism to a social media platform said no steps were taken to address the incident. It's an incredible report. Please take a look at it. Feel free to share it. Just in closing, somebody asked me this morning, so what if anything can we do about it now? I would say two things. The first would be AJC encourages the endorsement of the IRA working definition of anti-Semitism. Just to reiterate, IRA is the International Holocaust Remembrance Alliance. It has a working definition of anti-Semitism, which is crucial. The definition is a clear description of what anti-Semitism is. Before we fight it, we've got to define it. And domestically, AJC is encouraging local, state, regional, and national bodies to endorse the use of the working definition as a valuable educational tool. And then lastly, I just want to say, support the No Hate Act. We know that reporting hate crimes to the FBI in the United States is voluntary. We know there's a huge underreporting of hate crimes in the US, so we're urging the passing of the No Hate Act through Congress. So thank you for letting me share about AJC and our findings. Feel free to visit our website. If you need me, Alyssa and Harold Halpern, my dear friend, have my contact information. So we appreciate the opportunity. So thank you. Oops, I think you're muted, Alyssa. I'm sorry.
Thank you. Sorry about that. Thank you so much, Brian. So now we have Harold Halpern, and Harold will speak on Biden policy on the nuclear agreement and overall US-Israel policies, as well as the current status of Israeli politics. Thank you. Harold, take it away.
Alyssa, if you would, I sent you a couple of, there we go. All right. I'm going to talk a bit about the normalization agreements that were entered into. Now it's up to 5 countries, and a bit of the ramifications of the normalization agreements. This was a memorable occasion when the United Arab Emirates entered into an agreement. It recognized the legitimacy of Israel as a nation in the Middle East. Until then, if you recall the 3 no's of the Khartoum Conference of the Arab League right after the 1967 war. No recognition of Israel, no negotiations with Israel, no right of Israel to exist in our midst, in our Arab land. And that has been the mantra ever since the 1967 conference in Khartoum, Sudan. The Egyptian and the Jordan agreements with Israel were really not an exception because they were recapturing land that had been acquired by Israel in a defensive war. But now we're talking about a peacetime, normal normalization agreement, and now it's with United Arab Emirates, which you can see on the map, Bahrain, which you can see on the map, Sudan. Interesting, that's the Khartoum conference took place in Sudan, and you see that on the map. And now we have also the additional natural normalization agreement with the, I'm having a senior moment with the North African, Morocco, with Morocco. Now, all of these agreements are warm agreements, unlike the agreements with Egypt and Jordan. Those are government to government agreements. The populations of Egypt and the population of Jordan are not tuned in to the average Israeli. It's not a warm relationship. This is a very somehow I got muted again. Where was these are very warm relationships with the countries. The background of it, it didn't come about suddenly. For years, there were secret relationships with these countries for united efforts, and just as we now have with Israel has with Saudi Arabia. The timing did come about because under the Trump administration, the sanctions were reimposed as the United States removed itself from the nuclear agreement with Iran. These sanctions have been extremely effective in creating a very difficult economy for Iran, which means it had less funds to provide for its activities to destabilize the Arab Sunni nations. All of these are Sunni nations, with the exception of Bahrain. Bahrain is Sunni leadership, but its majority of the people are Shia. But they have a common interest, the Arab nations, with Israel in terms of restraining the activities of Iran. The nuclear agreement, which while it was in effect, did not in any way deal with the development of missiles or limit the support of Hezbollah in Lebanon or limit the support of Hamas in Gaza. And the Arab nations and Israel opposed the agreement with Iran. And now with a new president coming in, the nations wanted to solidify their common program to resist Iran and to encourage the new administration not to release sanctions, at least until a new agreement is reached with Iran, which provides for a longer period of time than the prior agreement, which provides for limitations on missile development and limitations on support of destabilizing and terrorist activities in the Middle East. And so there now is a common force in the Middle East, which President-elect Biden is listening to. He listens to them. He has a very emotional, not only a intellectual relationship with Israel, but he feels emotionally very close to it. He recognizes that conditions have changed since he was the vice president. He campaigned, however, on the basis that he wants to renew or restore the nuclear agreement, kind of silent as to whether he would release sanctions in order to get to Iran to the table. Iran said it isn't going to the table unless the sanctions are released. And so I think the Israel and now its new partners will pretty unanimously have its voice heard by President-elect Biden as to no further negotiations without the continuation of the sanctions. So these normalization agreements are important from a military point of view. They're important from the trade point of view, but and they're very important because it establishes the right of Israel to exist as a lawful nation in the Middle East. Until then, the United Arabs and the Palestinian Authority said all of this land legally is ours. So Israel was continually in a fight to establish its authenticity. Now, how does the normalization agreements affect the Palestinian Authority? Initially, their reaction was to call their fellow Arabs traitors, backstabbers. And now he is not doing that. He has restored security. The Palestinian Authority had cut off security cooperation with Israel. It's now restored that security cooperation with Israel. Palestinian Authority sees in President-elect Biden a more balanced approach to the relationship between Israel and the Palestinian Authority. However, those normalization agreements have nothing to do with the peace agreement between the Palestinians and Israel. Some have said it enhances the opportunity for a negotiation between the two, for negotiations to resume, because now the Arab nations have leverage over not only their Arab colleagues, but also leverage over Israel. Israel wants to maintain it, so that has to have a delicate balance in its activities in the West Bank. And some feel that that leverage may work to the benefit of the Palestinian Authority. On the other hand, others say that it's weakened the Palestinian authorities because it no longer has the leverage of saying you will not ever have an agreement with other Arab nations until you make peace. The reality is, Dennis Ross spoke recently here in Sarasota. And Dennis Ross has said the gap between the Palestinians and the Israelis is too big to be bridged. With the current leadership in Israel, the current leadership of the Palestinian Authority, and the current circumstances. So what is anticipated possibly as a result of this will be a less contentious relationship with the Palestinian Authority, more cooperative spirit, but not to count on any agreement between Israel and the Palestinian authorities in the near future. So I think that is the discussion of the normalization agreements. And now the key element of Israel and the concern of the other nations is the Iran nuclear agreement as to where our administration is going to head on this matter. And on that, they are united.
Harold, let me ask, if I could ask you a question. Do you think it's likely there will be a fourth election before Gantz becomes prime minister in November 2021?
You have another matter to put up on the screen.
Hold on. 1 second. There we go. Here we have the makeup of the Knesset by party.
This is I put this together maybe a week ago, a little too early, but this is the current makeup of the Knesset. If you know, there
Could
were.
you make it larger? It's hard to see.
I didn't hear.
No, he asked if we could make it larger. I can try, but probably not.
Or
I
you can
send
use
it-
your share screen to make it larger.
Right. No, I'm on it. Harold, if you could just explain, and we'll.
Yeah. Okay. There have been 3 elections of in Israel within the last 2 years, and the reason for the need for 3 elections is because the Israeli society is politically divided between right and left, and between Prime Minister Netanyahu for those who say yes to him, and others who say never another term in office. And so each time it's come out, and neither grouping of parties has been able to form a coalition until after the 3rd election. The Israeli system, just as a reminder to you, you do not vote for the prime minister. You do not vote for any member of the Knesset. You vote for a party list. And there are multiple parties in Israel. And each party gets representation in the Knesset in proportion to the percentage of its vote. And so no government in the history of Israel has ever been governed by a party which won the majority of votes. It's always had to be a coalition. But usually that has not been a problem. They're a coalition of like-thinking parties. But this time not. And so what this shows you is the current makeup of the Knesset. And I'll just read it briefly since it's too small to see on the screen. The Likud is 36. The 2 religious parties, Shas and UTJ together, are 16. The Derek Eretz is 2, and the Jewish Home is 1, and Gesher is 1. Those are the right-wing parties. Well, they don't make up a majority. So how did they finally, someone said, we can't afford within a year to have a 4th election. So the principal opponent was the relatively new party, Blue and White, which is chaired by former General Benny Gantz. Despite his having campaigned on the theme that he would never join Netanyahu, he said, for the good of the country, I'm breaking that promise and I'm joining in order to form a government. Well, the government has been dysfunctional because the coalition agreement that was prepared between the 2 leaders really creates 2 leaders. Each one of them, it's never happened before in Israel, each one of them has the power to veto the other power's appointments, to veto the other power's proposed legislation, and they have no budget for this current year. Here we're at the end of the year, no budget for this year and no budget for next year. The coalition agreement provides that if the current government does not adopt a budget for this year and next year by December 23rd, what's that, a week from now? If they don't adopt it by December 23rd, the Knesset will automatically dissolve and there will be new elections in March of next year. While we're waiting, and so the parties, the Likud and the Blue and White are negotiating, and as a result, the Blue and White is being threatened by its own membership of leaving. They're totally dissatisfied with with the functioning of the government and want to go to elections to see if they can get clarity in a new government. And while that's going on, there's another motion pending in the Knesset to voluntarily, now don't even wait until the 23rd, but for the Knesset to voluntarily dissolve itself. And that, the latest report is that that's likely to pass. But if not, Prime Minister Netanyahu has it in his hands to decide politically whether it's wise at this time for him or whether he should agree to a budget in order to defer the dissolution of the Knesset. If the parties adopt a budget, then that assures or that increases the likelihood that Gantz, who is now the alternate prime minister, will succeed to Netanyahu pursuant to the agreement on November of 2021, which Prime Minister is not likely to be happy about. So he is considering the political statistics, and the most recent poll I referred to in this document is now a little outdated, but it was a couple weeks ago, showed that the right-wing parties, the ones I've mentioned of Likud, Shas,
Hello? Yes, hi, how are you?
UTJ, and Yamina, which is now in the opposition, will have enough seats to form a government of the right or of the more right. And since I prepared this document, we now have another factor. Gideon Sa'ar, who was a member of Likud and who we met with, is an upcoming star. Also, he's actually right of Netanyahu, but left of him on social conditions. Now he's entered into the consideration as a candidate, as a leader of a new party. And the first polls showed that that new party would garner about 15 seats. Now it depends where these 15 seats comes to predict what will happen going forward. My thought is the only change is going to be made. He's going to take some seats from Likud. He's going to take some seats from Yamina, and you're going to still wind up with the fundamental fact that Israel is a divided country, right and left, and divided pro-Netanyahu and negative Netanyahu. So it's a great deal of uncertainty. And the uncertainty also is, when will there be an election? Will the Knesset itself dissolve? Then it'll be in March. Will December 23rd come without an agreement? Then it'll be March. If they don't vote for a dissolution, and if Netanyahu makes a deal again with Gantz, then the next election is uncertain of when it's happening. And my guess is that one way or another, we're going to see it in March, but that is, and that's an analysis based upon reading the commentaries in the Israel newspapers and talking with some of my political colleagues in Israel. So it's nothing more than an informed guess that, and this is creating many problems for Israel. They are not able to address other issues, very important social issues. So I think my time must be up by now. And I have a bad habit of exceeding my time, and I have much more to say, but I hope I have outlined decently the issues that I've discussed.
Thank you, Harold. Hopefully people will be able to stay a bit longer. So now we have Stan, who will discuss challenges to Israel's High Court, including the Knesset's proposed override law. So Stan, we know that Israel's form of government is different from ours here in the US. However, some of our attendees might not be familiar with some of the nuances of those differences that make it difficult for Americans to sometimes understand why the Israelis do what they do with regard to government actions and decisions. Please briefly explain some of these differences that may be confusing to some Americans.
Thank you, Alyssa. Thank you, Harold. When we first planned this trip, well, it's almost 2 years ago that it was conceived, I suggested that we meet with our counterparts in Israel, including lawyers, judges, academics, but I did not want to meet with politicians and rabbis. I quickly learned in Israel that it's almost impossible to discuss any issue without it becoming political. And sure enough, that's the way it goes. What I want to do is first introduce, as a way of introduction, to the Israel form of government. We know there's a Knesset. It's different from ours here in the US, which is what we think, the way we think is not the way they think. Our governments are different. Both are democracy, no question about that. In Israel, there's one branch of government, the Knesset, the legislature. In the US, as we know, we have 3 branches. And with that, the intention, at least in theory, is to have checks and balances on what happens, whether it's the legislature, the executive branch, which is our president, and the judiciary. We as lawyers think more in terms of looking at what the judiciary does and how it functions and where it's at. In Israel, the judiciary is not a separate independent branch of government. It is a part of the Ministry of Justice. I'll discuss in a little later how the justices are appointed, but suffice it to say that there are no checks and balances. The Supreme Court, or as it's called over there, the High Court, is charged with the responsibility of essentially deciding cases on a constitution that it doesn't have. Israel does not have a written constitution. There's been discussion about it ever since the country was founded. And in fact, in the Declaration of Independence, there is provision that a constitution will be written eventually, and that has not happened. In fact, several of our members over the years, when it was a hot issue over there, they actually were starting to consider doing it. Several of our members were brought in as consultants to assist in the process, which has not been active for quite some time. So the High Court, yes, it decides cases based on the laws as promulgated by the Knesset and certain basic laws, which Steve will discuss more in detail when he talks about the nation state law. But
I'm sorry. Oh, sorry. Sorry. One second. Muted. Ooh, Stan, unmute. I just tried to unmute you.
okay, I'm
Yeah,
unmuted
sorry
now.
about that.
Yeah.
Sorry about
Okay,
that.
I'm sorry. The Declaration of Independence in 1948, much like ours of 1776, is merely a statement of principles. It's not a law. It's not a statute. And it says things like Israel be a democracy. Israel is the birthplace of Jewish people. It mentions the Holocaust and the survivors. And it does say that it will be an independent Jewish state in Palestine, because at that time in 48, that's what the landmass was called. But it says specifically pending drafting of a constitution and many other provisions, but that part of the Declaration of Independence has not been fulfilled. Recently, however, which is kind of interesting, and I'd like to see where this one goes, recently a bill was introduced in the Knesset seeking to make the 1948 Declaration of Independence a basic law. And basic laws, Steve will describe later, are supposed to be laws that were adopted that eventually may be part of a constitution, and the court has interpreted them that way. So there is a law pending now, or has been introduced anyway, to make the Declaration of Independence, and maybe some changes along the way, into a basic law, which means that would result in requiring judges to interpret all Israeli legislation, including other basic laws that have been adopted before, in light of the terms and provisions of the Declaration of Independence, as though it were a constitutional document. Very interesting turn of events, and I think as lawyers, we may find it interesting as to where that eventually goes. The Declaration of Independence further provides the state of Israel would be based on freedom, justice, and peace, as envisioned by the prophets of Israel. It will ensure complete equality of social and political rights to all inhabitants, irrespective of religion, race, or sex. That's in the Declaration of Independence. The law courts in Israel constitute a separate independent unit within the Ministry of Justice, as I mentioned earlier. The head of the Ministry of Justice is a member of the Knesset and a cabinet member. The judiciary acts as Israel's watchdog over the rule of law and individual rights, as do similar institutions in other countries. However, the absence of a complete written constitution, including a Bill of Rights, as we would call it here, places the judiciary in Israel in a more important yet delicate position, because they're making decisions along those lines, and yet there's no statutory basis, or there's no constitution to rely on. The constitutional position of religious law in Israel has always been a controversial one, and indeed inherently problematic. And that's a discussion for another day. If we have time, I would talk about it, but I think that's last on my list of things to talk about today. There are two basic laws that have been adopted over the years, one called the Basic Law of Human Dignity and Freedom, and a Basic Law of Freedom of Vocation, that further confirmed that Israel is a Jewish and democratic state. The principle of equality is not explicitly stated in Israel's quasi-constitutional basic laws. However, the judges have interpreted the Basic Law of Human Dignity and Liberty to include equality. The Declaration of Independence is really just a statement of principles, as we have here, and it's the Knesset, though, is the important thing to know, is the Knesset is the sole branch of government and has full reign. The prime minister is not a president. They have a president, but it's more of a figurehead kind of position. The prime minister is elected from among the members of Knesset. And so the law courts are not independent as we would think here. And they're right. And many of us who feel that independent judiciary is essential in a democracy, that's debated there as well.
Stan, thank you so much. So there's been a lot of discussion in Israel about the manner in which justices are chosen for the High Court and the challenges to that process by the Knesset. Can you explain how justices are chosen and the proposal being suggested by some members of the Knesset to change the system, which would, according to the opposition, dilute the independence of the judiciary in a democracy?
Yeah, thank you. The judges are appointed by a blue ribbon committee or panel consisting of members representing the Israel Bar Association, the Knesset, several sitting high court justices are on that committee, and appointees from the Ministry of Justice itself. The object and goal is to make sure the committee is nonpartisan and non-political. I say that tongue in cheek. As an aside, the Attorney General of Israel is chosen in the same manner. He or she is not a member of the cabinet. The Attorney General is chosen by the Prime Minister from among the members of the Knesset. the Israel Attorney General serves a 7-year term independent of any changes in the Knesset and the government while he or she is serving. It's not like here where the Attorney General serves at the pleasure and concurrently with the President of the United States. The present Israeli government has been advocating for a change, as Alyssa mentioned in the question, change to the system of choosing justices for the High Court to one that gives the Knesset sole power and authority to appoint after holding hearings, similar to what our Senate does when there's a nominee from the president. But there, the sole choice, the Knesset is looking for the authority to make the sole appointment of justices to the High Court. I don't have to go into detail on how, again, those of us who advocate for an independent judiciary in a democracy would feel about that proposal, but that's coming from the Knesset now. So that's how they're chosen. In Israel also, for those of us who are lawyers in New Jersey, we can relate to this. There is a mandatory retirement. I'm not sure if it's 70 or 72. Here in New Jersey, it's 70. But the justices of the Supreme Court also are required to retire at that age. And many of them go on to teach and do other things. But we had the privilege of meeting with 4 retired High Court justices in the course of our 5 days of intensive meetings with everybody from these retired justices to academics to lawyers, and extremely interesting.
Stan, so if you could briefly discuss the controversial hot topic among the legal community in Israel is the proposed override clause amendment to the basic law of human dignity and freedom. So Steve discussed in general hold on one second. What would you like? Sorry, Stan, I know this is something that you wanted to discuss. We changed our order, so.
Well, yeah, that to me is probably one of the most interesting and important things that came out of this trip that the Knesset has been debating now for a while, an amendment to the basic law of human dignity and freedom to give the Knesset the right to override or overrule any decision of the High Court. I found that astounding when I first heard it, but yet they're very serious about it. So that if the High Court makes a ruling, the Knesset wants the right to override that ruling of the court by a simple majority. What I found also interesting, and I think all of us were kind of surprised, when we met with retired Chief Justice, or there they call it the President of the Court, Aaron Barak, who is known to be a liberal, progressive jurist, and was good friends with Antonin Scalia, as a matter of fact. When we discussed this idea of the override law, we thought for sure he was going to say, oh, yeah, no, it's no good, whatever. He said, no, he could live with that, provided, that it's not a simple majority that could overrule a decision of the High Court. If it was some sort of supermajority, he threw out the number of 90 out of 120 votes in the Knesset. He preferred higher, but he could settle for 90. Well, that's a supermajority, probably would be, as the way the politics in the Knesset are and have been, that would be a virtual impossibility. So it effectively would be an ineffective provision as an amendment to the human dignity and freedom basic law. So the override law is a concern as well for the thing I mentioned a few minutes ago of an independent judiciary in a democracy. This would essentially take that right out of their hands. The Supreme Court or the High Court in Israel, by the way, I didn't mention, I think a lot of people know, it's also a court of original jurisdiction. So they hear, I forget the number, but thousands more cases per year than our Supreme Court does. But it's also a larger bench. I think they have 14 or 15 justices, and they don't all hear every case. The president of the court can divide the team and assign 3 judges to hear this case, another 3 or 5 to hear another case. But the point is that if you have in certain cases, you can bring the case directly to the Supreme Court. You don't have to go to the lower courts, but they also, of course, hear appeals. So that this override provision is very controversial, and I'm not sure where it's at now. I have a cousin who's the chief judge of the Haifa court district, and I emailed him a few days ago asking if he could update me on it, and I haven't gotten a reply. But the point is that the court is not independent, and that's one of the things that I came away from this trip with being very of a big concern.
Thank you, Stan. Thank you so much. And again, I hope that people will be able to stay with us a little past 1, a little past your lunch breaks, because we still have our president, Steve Greenwald, speaking about the nation state law, which I will put up. I'll put up the text on the screen. I'll also circulate these materials after, so you don't have to worry. Steve, if you could recap the history of the nation state law and discuss litigation over the law pending in the High Court, that would be great. And I'm gonna share the screen now.
Okay. Can you hear me? Am I on? Okay.
Yes.
Oh, I see, that's also very small print, but I'll,
Oh.
You're going to be sending it out to everyone.
I am. I think that should be a little bigger, but it is 3 pages long that I put on one. So.
Right. All right. In the time we have left, let me cover a number of things. The nation state law was enacted, I think, about 2 years ago. Actually, it's been around for a long time. It was intended to be the preface to the Declaration of Independence of Israel, but it wasn't. That didn't happen. And then about 2 years ago, it was enacted as a basic law. And it was controversial from the outset. And we wanted to learn more about it because one of the things that happened was that there was a lot of attention paid for those who were interested in what's going on in Israel in the New York Times and elsewhere about this law and the meaning of the law and what it said about democracy in Israel. So a lot of attention was paid to the law. So we met. We had with numbers of people to discuss this law, particularly with Eli Rubinstein, a former justice of the Supreme Court of Israel. Many of you will know who Eli is, and also with Susie Navot, who's a highly regarded constitutional law expert in Israel. And they were working on proposing some amendments to the law, and I'll tell you where when I discuss it. But on a couple of particular parts of the law that were very controversial. I spoke to Susie recently, and they've really gotten nowhere in terms of amending these provisions that they were concerned about. There is now a case or a hearing set in the High Court, in the Supreme Court of Israel for, I think it's going to take place next week, sometime later this month. It's the first actions that were filed against, as it were, against the nation state law. And there were 15 petitions that were filed by different parties making different arguments about why the law was unconstitutional, I'll use that term, and needed to be amended or in various ways. or reinterpreted in various ways. Also, the court assigned it to an 11-judge panel, which is which is unusual. The number of justices who are assigned to particular cases in the sort of typical case would be 3 justices, maybe 5 justices, but it's a very rare case where as many as 11 out of 14 or 15 justices are on a panel for a particular case. And I think it indicates the importance of the case, or the cases, in the eyes of the court and in the eyes of the government as well. So, so I thought I would, in the time I have, the best way to discuss the law would be to talk about what the opponents to the law are concerned about and the main points that are raised by the petitioners in these cases. And most attention has been paid in regard to 2 of the provisions of the law. The provision in Article 1 that self-determination is uniquely, where is that language? Self-determination of the Jewish people or self-determination is unique to the Jewish people of Israel, meaning, as in its plain meaning, that only the Jewish people have a right to self-determination in terms of their rights and future and so forth. And this, obviously, that's created a lot of controversy. I think it's obvious, it should be obvious. The other provision that is received a lot of attention is Article 7, which says the state views the development of Jewish settlements as a national value and shall encourage and promote the establishment and strengthening of Jewish settlements. Those are the 2 that have attracted the most attention, and I'll talk about them in a minute. There's also a provision that reduced the status, if you will, of the Arab language, which since the founding of Israel was always on a par with the Hebrew as an official language. It was its status was reduced to a special language. That's also attracted attention. So let me go through some of the main points raised by petitioners. And by the way, I think for those of us or you or us who are interested in constitutional law and constitutions generally, this is the best game in town right now. The arguments over this nation state law, I think, are fascinating for people who are interested in constitutional issues, a couple of which I'll touch on. First of all, petitioners argue that this law, the nation state basic law, and it is a basic law, would make Israel's constitution. And let me just back up for a second. Stan mentioned that Israel has no constitution. Actually, the court has taken the position, spearheaded by Barak, that the basic laws that have already been enacted, there's about 5 basic laws that have already been enacted, that they do constitute a constitution, or parts of what will ultimately be a full constitution. So to that extent, the petitioners in these cases are referring to Israel's constitution, meaning the basic laws that are in place now. So, which again, the court recognizes as a partial constitution, at least. So the first argument is that this law would make Israel's constitution the only constitution in the world that designates the regime as serving only one ethnic group in regard to self-determination and other rights. Second argument is that the law, the nation state law, violates the right to human dignity, which is also a basic law, and the right to equality, which is not a basic law, but has been recognized by the Israeli Supreme Court as derived from the right to human dignity. And I'll talk in a few minutes about one particular case, the Canaan case, which also implicates paragraph 7 of the, or Article 7 of this nation state law, and seems to run counter, what's happened here seems to run counter to what was decided in the Canaan case on equality. Essentially, the court, Aaron Barak, invoked the concept of equality and said that equality is part of the basic law of human dignity, or can be derived from the law of human dignity, and therefore is part of the Israeli Constitution. The petitioners rebut the argument by the state, which is that the law is merely declaratory, in the sense that most of its provisions are already grounded in daily practice and politics and laws and rulings. And petitioners argue that even if this was the case, which they dispute, elevating the status of those practices to constitutional status makes even overtly discriminatory practices that could have been challenged under the basic law of human dignity now are made permanent and given a constitutional status that makes it much more difficult to challenge those laws. So it would be as if a law, an American law, was incorporated into the Constitution. We know that it's much more difficult to challenge a constitutional provision than it is an ordinary law. But that's an argument that's being made by the state. As to the Article 1 statement that self-determination is unique to the Jewish people, what that basically means, the petitioners say, is that only Jews can decide on the allocation of basic rights to non-Jewish residents. And if we want to indulge in some hypotheticals, we could think of hypotheticals. For example, let's say the Knesset wanted to pass a law regarding annexation of some of the West Bank, for example. Would it be possible under this Article 1 to provide that if the law was, if they made it into a law that had to be approved by the people, for example, which has happened in Israel, could they provide that only Jews could vote on this law? In other words, block non-Jews from voting on that kind of a law. So that's another argument they make. Another argument is that the law violates human rights law by establishing a constitutional order that's based on racial supremacy and ethnic domination, contrary to popular sovereignty and equality for all, as is expressed in Israel's Declaration of Independence. Which we'll talk about later. In a few minutes, I'll talk about what's called meta-constitutional arguments that can be made to undermine this particular law. They also make the argument that ethnic supremacy, which is a consequence of this law, violates the existing law of human dignity, which it probably does. And so then you have a clash between two basic laws, and how that gets worked out has not yet been settled really by the Supreme Court. As to Article 7, the argument is that Article 7 constitutionally entrenches racial discrimination in connection with matters of development of land and is directly in conflict with and overrides the Canaan decision that the state, and that's the decision I was referring to earlier, that held that the state must treat its citizens equally and prohibited discrimination as to all matters related to settlement, land allocation, and housing. And I referred to the Canaan decision earlier because the Canaan decision also is where Barak, then Chief Justice Barak, held that that there was an equality right, that the right to equality was implicated by the law of human dignity, and that in this particular case, the court ruled that the state was duty-bound to premise all of its actions on the basis of equality, and that this duty was constitutionally based. So you have the Canaan case, which says that the concept of equality is in the Constitution, presumably in the human rights law in that case. So this would override in effect or be in conflict with that law and that principle. They also argue that ethnic supremacy itself violates the law of human dignity. As to Article 7, as I said, the argument is that this is directly in conflict with the Canaan decision. In the interest of time, let me move on quickly. Petitioners also invoke the doctrine of unconstitutional constitutional amendments. Is it possible for the Supreme Court of Israel to find a basic law which is a constitutional, has constitutional status according to the Supreme Court, unconstitutional? How do you find a basic law or a constitutional provision unconstitutional? Well, the only way you can do that, according to the petitioners, is to go to the concepts of what they call meta-constitutional concepts, such as equality and human rights, that should bear on the that should be implicated in assessing these laws, and it should bear on the validity of the law. This is a position that the Attorney General in his response to these petitions has rejected. Now, Stan mentioned that there was a movement to make the Declaration of Independence a basic law. So, but even if it isn't a basic law, and then you might have a conflict, of course, between two basic laws, and that's never been addressed by the Supreme Court of Israel. But even if you didn't make it a basic law, there are, in the United States, for example, I looked at this about a year ago when we were first looking at these cases and the nation state law, and there's many opinions of the US Supreme Court which invoke the Declaration of Independence of the United States, not as being law, but as being interpretive tools to interpret the meaning of language in constitutional provisions. So here, the petitioners are arguing that equality is one of the stated. The Declaration of Independence says that equality will be respected in Israel, and so they're making the argument we could look to that, or the court needs to look to that to interpret the meaning of this basic law and read into it basically an equality requirement. And just to wrap it up, the Attorney General's brief relies on argument that the law is, as I said earlier, is declarative of existing laws and practices. And I think I discussed what the petitioner's view was on that. And with regard to Article 7, the AG argues that the discriminatory practices would still be disallowed based on the Canaan, as the Canaan ruling requires. The AG, what he argues is that the petitioner's claims are not, he also says they're not ripe for decision, and that the presumption that the law would be applied on a non-constitutional basis is not ripe for decision either. In other words, give us more time. There hasn't been enough time to see what will happen in the actual application of the law, is what the Attorney General is arguing. So these petitions are premature. And the AG also rejects the concept of meta-constitutional concepts and a reliance on the language of the Declaration of Independence. So, so those are the main arguments made by the petitioners. There are 15 petitions, so there are others as well. There is only one case that I'm aware of that has actually invoked the nation state law. I might be wrong on this, but it got some publicity. It was a few weeks ago, coming from a small municipality in northern Israel, where the Arab residents of the municipality had reasons to send their children to an Arab school, or an Arab school outside the city, outside the town of the city, and were seeking funding or it brought a case to have the municipality cover the costs of that. And in the decision by the local judge, a municipal judge, he ruled in favor of the town or the municipality, but he did invoke, at the end of his opinion, he invoked the nation state law and said that, and it's not clear he really didn't argue it out, as I understand it, with any clarity, but he basically said, what you're asking for would be a violation of the nation state law in some way. As far as I know, it hasn't been applied elsewhere in other cases. So we have this case coming up next week. I think it's the 22nd or 23rd of December, as I said, and we'll see what happens.
Sorry, Stephen, who is the petitioner?
What?
Who is the petitioner?
There's 15 different petitioners. I do not have a list of them. There's 15 petitioners, and as I said, there's a group. It's an 11-judge panel, which is a large panel, and very unusual to have that many justices on the panel. So it's being taken seriously, obviously, by both sides. And then so it's interesting if, as I think I might have said this already, but if the Declaration of Independence of Israel is elevated to a basic law, that Declaration of Independence talks specifically about equality. And it would be, there would be interesting challenges and cases ahead. So as I said, I think that we'll know more in a few. The court will probably take a great deal of time to decide it, but sometime next year we'll know more about this. But I do find it to be a fascinating exercise in constitutional law, invoking these concepts like meta-constitutional concepts like equality and so forth. Is that permissible or not? Should it be permissible or not? And what does this say about Israel's claim to be a democratic state? And that's really what's at the bottom. I think it's one of the bottom line of all of this, looking at the nation state law. What does that say about Israel being a democratic state? And I go back just to make the one reference that was made by the petitioners, that this would be the only constitution, because it is a constitution, according to the court itself, only constitution that has this kind of ethnic discrimination built into the Constitution itself. Not something that Israel would want to brag about, in my opinion. So thank you.
Thank you. Thank you to everybody, to Harold, Stan, and Steve, and Brian Lipton, of course. As I said, I will send out follow-up about the AJC report.
What about the questions you want?
We have a few questions. I was getting there. We have a few questions, mostly comments, kind of disguised as questions, but so I'm parsing through to get to the questions. Sam Tenenbaum mentioned Israel, Turkey. If anybody wants to discuss that briefly. I'm not sure if you're still there, Sam, if you have anything specific you want to add. I think he's actually gone.
Okay.
So let me see if I have people who are still on, who have questions. Okay. Elaine and Peter Buxbaum are still here. So much as I oppose the nation state law, how can a constitutional basic law be voided as unconstitutional? The unconstitutional amendment doctrine, like repealing the First Amendment in the US?
Well, that's a dilemma. I mean, that's the question. How can a constitutional provision be unconstitutional? The Attorney General's brief, as I understand it, dismisses that out of hand, basically saying, well, that's impossible, but I don't know whether it's impossible or not. I don't think it's ever happened here in the United States. The way we deal with unconstitutional provisions is to revoke them. We've revoked some of the original original parts of the Constitution in the United States. But that's where this concept of appealing to what the proponents here call meta-constitutional understandings comes into play. And I'm not enough of a constitutional legal scholar myself to say whether that has happened anywhere in the world, but I did mention that the US Supreme Court on numerous occasions, as a matter of interpretation, has resorted to or looked at the provisions of some provisions of the Declaration of Independence, which is not part of the Constitution itself, but is an external document. But they have looked at that as an interpretive tool, and that's one of the things that's being requested here.
Let me join in this little discussion. The classic interpretive construction is you interpret it a way in which it is not in conflict, and I think that will be the result. As we frequently interpret our own Bill of Rights, we balance the two and determine which one has the upper hand. And so I'm sure that the balancing, you don't have to face the question. The other thing about the nation state law, the Israeli Declaration of Independence is a beautifully written document that democracy rings throughout it. But in that declaration, it clearly states, we are both a Jewish state and a democracy. So those who object to, it's very consistent. Everything is very consistent. And the right of equality is so incorporated in all the decisions of the court that is not going to be diminished by any contrary interpretation of the nation state law. So I'm a little bit more sanguine about this. It's typical for a country writing a constitution to declare its purpose. And its purpose is to be a Jewish state and a democracy. And I feel quite confident that that will remain the case, particularly with this very liberal Supreme Court. Now, one other comment I make is stand in saying that Scalia and Barak were friends.
Yeah, they were.
But in the same way that RBG and Scalia were friends.
Right, that's the point, because there was a comment there was a comment in the chat with a question mark.
That was misunderstood. I was trying to reply to that.
They're totally
we can tell stories.
Yeah.
I could tell some stories about that too.
Yeah, I have some stories. I talked to Scalia about Barak, and he looked at me as that he's a good friend. He looked at me as if I was nuts. But anyway, I'm more sanguine on the nation.
I think my prediction is that the court is going to finesse the whole issue on the argument, some of the arguments made by the Attorney General, that it's not ripe, whatever that means, for decision, and that nothing's really happened yet. So let's wait until something happens. I don't think they're going to count this case from a municipal judge in Israel. So that's my guess. They'll push it down the road. So
both were guessing the same thing, that it's not something.
It's fascinating. I think it's a fascinating, interpretive matter for lawyers, who are interested in constitutions and constitutional issues.
Well, the same thing with the override law, which is in fact been debated for a couple of years now. It hasn't passed yet, but I find the same issues. If that becomes law, then the Supreme Court is useless.
Well, I wouldn't go that far, but in controversial matters, the Knesset can overrule them. That's nonsense. That's ludicrous.
Well, remember what Barak said.
Yeah, I know. He said
what Barak said. Listen, the United States, you can amend your constitution
Right,
too.
right.
This
Right.
is our way of amending the constitution.
Right, that's
Yeah,
what
but he also said though that he could live with it if it required a
Significant.
minimum of 90 votes.
Yeah,
And Rubenstein, when we talked to Rubenstein about it, he said, look, you've been at this for 240 years. We only got 70 under our belt. We're still learning.
Well, now you have the privilege of listening to differences among those who were on the trip to
yeah,
Israel.
we should.
All right,
back.
so
Let's go back to,
yeah, so it looks like we don't, if we do have more questions, I think a lot of people have unfortunately dropped off. So if you guys don't mind, I'll send your emails out if you're able to answer any more
yes, please.
questions that people come up with. And I'm just gonna close with my own comments since I actually was also on the trip. And we had a couple of questions about, I guess, the general experience. I'll just relate one quick anecdote. So I was on all these meetings with Steve, Stan, and Harold and some other members. And we had this one meeting with, his name was Nahum Barnea. He's an Israeli journalist, very, very interesting guy. And this was something that, was striking about our visit. And I remember Stan asked something about how he can get, his grandkids interested in these subjects the way that he is, and the way that, of course, Harold and Steve is. And I, sat there and I said, well, I guess that's something that I have to address more because I'm relatively close in age to Stan's grandchildren, I believe. I'm maybe a little bit older. So I think that that's something really important that we do deal with in the community, especially when it comes to Israel. I think engagement is lower. I'm sure Brian, of course, working for the AJC deals with that as well. So I think I don't have a solution right now. I do have some ideas that I would need other people to help me implement, but I hope that at least everybody can talk to their children and grandchildren and try to get them as interested in these subjects as we are, as you guys are, because Israel is very important to me and hopefully to other people in my generation, though unfortunately it's dwindling a bit. And to respond to Howard Gluckman about whether were the Israeli attorneys and jurists interested in hearing our opinions as American lawyers? A little bit.
Barno also said, no, they're not interested.
Not really. Not really, no. Well, the people we spoke to were interested, but they said nobody else really is interested. So there you have it. So thank you so much to everybody who stayed, and thank you to Steve, Stan, Harold, and Brian. And I'll get you all these materials, and you're all welcome to follow up with us.
I have to butt in. I think it's an overstatement to say that there is no interest.
That's what Barney had said.
We talked about certain critical areas where they say U.S. Jewry has to understand our point of view.
Right.
We have to understand your point of view. I can't agree that the impression I have is there's a concern.
Something that Barney has said to us.
Barney has said to us, hey guys, don't think that you guys are so worried about the West Bank settlement. It's not going to happen. So forget it during your lifetime.
No, but he also did say they don't care what you think. So,
Well,
but he was the only one who said that, and I agree with what was just said. I think they do care, and I think that we should keep dialogues going between, not at the national level, but certainly at the lawyer level if we can. So with lawyers and legislators in Israel. So
absolutely, our relationship with Israel as American Jews is still important. Thank you to everybody.
And as lawyers, because I think we learned a lot as lawyers in this trip.
Very
yes.
Okay.
Well,
Alyssa,
thank you.
right.
so thank you for all your effort as well.
Thank you, Alyssa.
Thank you to everybody.
Long, everybody.
Have a great day.
Bye.
Don't
Take
eat too
care.
many
Happy
latkes.
Hanukkah. Enjoy the snow.
Bye-bye.
Bye.
And Harold, take care.
Bye-bye.
Happy Hanukkah. Happy New Year.
Don't eat too many latkes.